So shall we start with insolvency resolution?
Yeah, the IBBA has notified the insolvency resolution process regulations for personal guarantors to the corporate debtor, and the process of personal insolvency resolution process, that is PIRP, is something similar to our CIRP process. And thereafter, once the PIRP process is concluded, or if repayment plan is not approved by creditors, or there are certain conditions which has to be met, in case the personal insolvency process is not like in case the PIRP process is not concluded, the process will go to the bankruptcy process. The bankruptcy process is more like the liquidation process for the corporate debtor. The process remains almost the same. The conditions are different. So we'll start with the PIRP. Yeah. So these regulations may be called IPBI, IRP, CP. I'm just reading in the short form. Insolvency resolution process for personal guarantors regulations. They have come into effect from 1st December 2019. So these regulations shall apply to the insolvency resolution process for personal guarantors to corporate debtors.
Ma'am, one thing, when you present now, so we don't need to go to with the full name, because everyone over here insolvency
IRP, CP, and we can call PIRP, sir. Personal insolvency resolution process, PIRP we can call.
It is enough. Short forms are enough. Everyone understands.
Yeah,
sure,
fine.
Sure.
So this session was actually preponed, sir. This session was on 9th. So I was just, we were handling around 8 personal guarantors matter in personal insolvency. So I can brief on the personal insolvency process regulations, and bankruptcy regulations I have just gone through, but practically I have not handled the bankruptcy process. So I need participation from all of you. And I need help from Pankaj Khetan, sir.
When you are dealt with 8 cases, you just share with your personal experience also whenever you are discussing with the regulations also, so it will be beneficial for
absolutely all. Absolutely, sir. Yes, for 6 personal guarantors the process is concluded, and for 2 guarantors the process is going on now. Definitely, whenever we come across any regulation which we are practically facing any difficulty or any issue, I will surely share our experience, sir.
Madam, if possible, can you give a little overview of the process is completed, initiation process, so that it may benefit because it's a very new law.
Yes, sir. Sir, first the application will be made under section 94 or 95. 94 by the personal guarantor himself, 95 by the creditor. So once the application is made, along with the application, the financial creditor also recommends the resolution professional for the process. So after hearing, the matter gets admitted, and section 99 order is passed. Section 98 order is passed by NCLT declaring interim moratorium and asking for a report from the resolution professional whether the matter requires to be admitted into the personal insolvency process. At this point of time, an interim moratorium is declared, and RP has to file a report with the NCLT verifying the application filed by the financial creditor whether this is a deemed fit case under the section 99, and he has to file a report under 100. So he has to verify the application and whether the debt exists, and demand notice is issued and the debt remains unpaid, and he has to verify certain criteria, and he has to recommend to the NCLT through an IA recommending the admission into the PIRP. So most of the cases, whenever financial creditor are filing, it is a fit case for admission. So in our 6 guarantor cases, we have filed recommending for the insolvency commencement of the PIRP process. So during this time, what practically we have seen is under section 99 and regulation number, while going through, I can tell you, there is a specific clause which says the resolution professional can seek information from anyone. This is where the resolution professional is having the powers to seek the information regarding the guarantor from anyone. Like the basically here the guarantors, when we prepare the statement of affairs, we need to have the complete details of income tax returns and the financial information of the guarantor. So the power given to RP is, before filing the section 100 report with NCLT, RP can write to anyone. So here, if you want any information, if you have some information from the financial creditor that there are some foreign assets or any income is not disclosed, you can write to the income tax department. In one of our cases, we wrote to income tax department, but as usual, we have not received any information. So this is the where, after going through, you will file an IA recommending the for the personal insolvency process to commence. So after
Madam,
that,
after that anything has been done, because Supreme Court has given some stay, na? After that anything?
Sir, in some of our cases, it is admitted, sir. Now in recently Amaravati bench admitted in one of our personal guarantors matter, and one NCLT Hyderabad also.
No, what I meant to say, in Sanjay Singhal versus Union of India in 2022, Supreme Court has already clearly given the instruction not to proceed, and no NCLT court is proceeding against a personal guarantor. Sir, based on that, some of the guarantors applications are pending, but recently in May we got one admission, sir. In May. No, what I mean to say, madam, everyone is taking the shelter of the Supreme Court decision is a final outcome of that decision, because Supreme Court has already stated in one or two cases. One is Sanjay Singhal versus Union of India, and 2 more cases are there.
Yes.
Mr. Jain, what is the position?
Yes, sir. Yes, sir.
If any personal guarantor oppose that application,
yes,
then only NCLT will give a stay. If there is no opposition from anyone, then straightway that will be admitted.
No, Pankaj, who is going for personal effecting the personal guarantee case, they are taking the case law of Sanjay Singhal versus Union of India, sir.
Sir, you are very much right, but there are many persons.
Sir, there are many cases admitted under section 95 as well as 94.
Who want to settle the matter.
Yes, sir.
Who are the genuine borrower? Who are the genuine personal guarantor? They want to settle the matter.
Sir, there are many cases admitted in 95.
So, Supreme Court matter is not the blanket ban on all the matters which are coming up with the NCLT.
As a Pankaj,
yes, sir. Yes.
Pankaj, can you give some light how long the Supreme Court matter will continue? This is pending for last 1 year.
Right.
In the interest of the profession, these issues should be resolved as early as possible. Why there is a delay of 1 year by the Supreme Court? Can you explain, please?
Sir, we cannot give any explanation on the court.
No. Sir, I think someone should take a...
One suggestion can be made. The petitioner or whosoever is petitioner can move an earlier hearing application stating the reasons, grounds of urgency, so that matter can be taken up fast.
Sir, this everyone knows. The Supreme Court should assume
You can't. What else you can do with the Supreme Court?
No, a lot of cases are pending in the NCLT in different courts, Chandigarh, Delhi, other courts. They're not hearing for the last 1 year.
That's true. That's true. I think, Suhasini, we should go regulation by regulation. Our mandate is to seek the some changes which we can suggest to the IBBI.
And at least our IPA should maybe at least through some forum, they should take some initiative so that the Supreme Court should resolve the matter immediately.
Mr. Sanjay, it will be better if you write to the IPA over the mail, then it will be more fruitful.
Ma'am, just want to know, as you have told that we can get information from anyone. So suppose we don't have any PAN number or anything, how you proceed in the case of
Mr. Rakesh, sorry, I am interrupting you. Can we go for regulation by regulation, and after that we can raise our queries with the Suhasini?
Yes, sir. Thank you.
Thank you. So Suhasini, we should go regulation wise and seek the suggestions. Then we will go for the discussions.
Right.
Okay, sir. Sure. Sir, will not take up the definitions then.
Okay.
Yeah.
So anyone want any amendment in the
definitions?
Ali, give your suggestions. No. Next.
No.
Next.
Yeah.
Next. Nitika, next. Eligibility of RP.
Eligibility, yes. So an insolvency profession.
It would be same like any other.
Yeah.
Any suggestions?
Any other? Yes.
It would be same. It cannot be changed because
it cannot be changed.
Yes,
sir.
Next.
These are reasonable. Yes.
I had a suggestion on this.
Yeah, please.
Because here we are saying in item C, explanation, he has not acted or is not acting as IRP, RP or liquidator in respect of the corporate debtor. I think this should be removed because it is better if a person who's handled the corporate debtor and he also handles the personal guarantor's case. It saves a lot of time and effort, especially from a client's perspective.
See, Mr. Patel, as far as you're saying, it is 100% correct. The person who is handling the CIRP process is well aware about the promoters and the guarantors, all about things. And when the new person will come, then he has to seek information from scratch. But here, in my view, it's my personal view, what was the intention behind this, to keep this clause, to make the thing independent from the CIRP process, so that there should not be any corruption matter arises on later stage. It's my view, but we can suggest the
we can suggest for rethinking over this topic.
Yes,
we can give the suggestion to rethink over this topic like this.
Nitika,
here we have a suggestion that in case the applicant is guarantor himself, there this clause can continue. But where the applicant is a financial creditor or any other creditor, the existing IP can or IRP can handle the.
Okay, fair enough. Note it down. Next, any other suggestion? Next.
Sir, I just need to clarify, like when the FC is the applicant, then the same IRP RP can continue. This is the final.
Sorry,
when the financial creditor is the applicant, then the same IRP RP can continue.
Yes. Okay. Next. Yes, Suhasini.
Yes. The preservation of records There is no specific in like unlike CRP and liquidation regulations, they have not prescribed any number of years here. It will be communicated by the board.
So
it should be, yeah.
It should be. Otherwise, after
they should prescribe.
It should be as per our suggestion.
They should prescribe.
CIRP. It should be 3 years. 3 years.
3 years. Yes.
So we can note it down, Nitika, in this way. There is no timeline provided under this regulation. It depicts the unlimited time.
Okay.
So we can keep it for 3 years.
Sir, it has two options, sir. One is physical and electronic also. Of course.
Yes. Electronic.
Yes, both.
Both 3 years.
Physical as well as electronics. We have to keep the both.
Yes.
I think if once keep the electronic record, physical is not required.
No, sir, physical as well as, kindly see the wording, physical as well as electronic.
We can give suggestion. If we are keeping electronic records, please give the suggestion to keep the electronic records only. Now digital era has come.
Fair enough.
Okay.
Next. Suhasini,
Next,
carry on.
submission, registration of claims. Nitika, can you take the slide up? Yeah. The creditor.
Ma'am, or we can say that, physical records can be destroyed after 3 years. If electronic records are there.
But there is some limitation for keeping electronic records as well.
It would be mandatory to keep the records in electronic form for 3 years at least. It can be done. Something like this. Keeping the physical record, if you are doing too many cases and etc., you are involved in this. So it is very difficult for you preserving all those records. So you can, of course, preserve the record in electronic format, in pen drive or somewhere. So it is better to keep it electronic only.
Or
5 years, no problem.
Or ma'am, one thing can be done is that, there should be a centralized custody, by a regulator, that the records, physical records should be deposited
there. It is already available.
It
is already available. You can check the NESL, not for a physical, for electronic maintenance.
No, physical. I'm talking about physical.
Physical, you have to make your own arrangement. We have.
No, that's what I'm saying. It's very difficult. So there can be a provision by regulator.
It's not practical feasible, Anilji. It's not practical feasible. IBBI is here to regulate, not here to keep the records.
Their position will change.
That's why I'm saying. We should talk in a practical way. Anyway, Suhasini, please carry on. Regulation 7.
Yeah.
Any suggestions?
Regulation 7, creditor.
Yeah, please.
Any suggestions here? So based on the public notice issued after admission of the personal guarantor matter into the PIRP process, a public notice will be issued by the resolution professional in the English circulated where the PG is residing and even in the vernacular language. After that, the creditors will start submitting the claims. The claim form B is prescribed form. And public notice, there is no format we have to devise. That is already a lot of are available on IBBI site.
Yeah, ma'am, one suggestion here. So I'm handling a live PG to CD case. So one suggestion here is if we compare this scenario with the CIRP scenario, there we have the maximum limit of 90 days, right? So there should be something similar to be brought out for PG to CD as well. Yeah. Hope I was audible.
Days. Yeah, you are audible.
Good suggestion. There is no timeline provided for submission and verification of the claim. So there must be some timeline.
Correct.
Otherwise, it will be an unending process.
Yes, exactly, sir.
Yes.
Good suggestion.
The thing is, sir, we have got the timeline to submit the repayment plan along with the report to adjudicating authority within 21 days from the last day to receive the claims.
We are not audible.
No issue.
Sorry, yeah. I was saying that from a timeline point of view, the point currently is within 21 days from the last day of claims, we have to submit our repayment plan if at all we have received, along with the RP's report to adjudicating authority. So within that period, we will have to finalize the claims is what the clue basis which we are proceeding. But the wider time limit, similar to 90 days in CARP, has to be definitely clearly spelled out, is what I think, sir. Yeah.
90 days will be too high timeline because you have to submit the report within 21 days.
Yes. Yeah. I'm not saying that. I'm not saying 90 days, but something similar to that has to be brought out.
Here in the personal guarantor case, we cannot compare it with the CIRP. So in my view, if we have to submit the report within 21 days, then there should be 14 days or 7 days or 10 days timeline should be there.
Yeah. Then what about the claims if we are receiving after that deadline?
Then in the same way, we have to go
to NCLT.
with the NCLT.
Some sort of public announcement format may be introduced.
Sir, list of creditors can be modified by the RP. And during the repayment plan negotiations with the creditors, the guarantor can always provide based on the list of creditors provided to him.
Okay.
Yeah.
Okay. Next regulations.
Pankaj, I think Pankaj, in this, regulations, in these regulations, I think formats should also be provided. Like in CIRP, it's essential. Okay. I mean, it will be useful.
Fair enough. So for
formats for what?
Format for publication,
public announcement, etc. All like
all
CIRP.
format like CIRP. Right?
Yeah, I had one suggestion.
Yeah, please.
In the case of CIRP, for financial creditors, they have to submit their claim by electronic means. I would suggest that we have a similar regulation over here also. All the financial creditors should submit their claims by electronic.
Fair enough. Next, transfer of debt due to creditors. Any suggestion? Yes, Suhasini, share your experience.
Sir, this is like CIRP. If there is a transfer of debt due to creditors, the same shall be notified by each creditor, and the RP will again notify each creditor and the adjudicating authority of any resultant change in the list of creditors within 2 days. This is something similar like our CIRP.
Any suggestion for improvement?
Same as CIRP, no? So it doesn't matter.
I don't think. Then next. Suhasini, carry on.
Yeah, the list of creditors shall contain the names of creditors. The RP shall make and available inspection for the persons who submitted claim, and also serve a copy of the list of creditors to the guarantor. This is one of the important point which the RPs have to remember. We have to serve a copy to the list of creditors to the guarantor also as well, along with the creditors, and make available on the website of the guarantor. This may not be possible, but if IP is maintaining any website, on that we have to put. And file a certified copy along with the repayment plan. Here, unlike CIRP, in CIRP we have to file a list of creditors with AA immediately after modifying. But here, along with the repayment plan only, we have to file the list of creditors.
It means during that period we can modify any number of times the list of creditors.
Sir, based on it can be modified, sir. Based on if any additional creditor comes. It can be modified, sir. There is a regulation on that. Regulation or somewhere in section it is there.
Right.
When additional information is there. Any additional information.
Yes.
Absolutely, yes.
Any other suggestion?
Pankaj, the list of creditors should be in the creditor name wise.
Sir, a lot of noise is coming from your side.
No, sir. From my side, it is not there. Hello.
Hanji, okay.
Pankaj, the name of syndicator is to be listed on creditor wise. In most of the CIP cases, the website is showing only the financial creditor, workers creditor, employee or operational creditor. They are not showing the name of the creditor, sir.
No, sir. Kindly see the IBBI website.
I have seen the IBBI website.
The details with percentage is mandatory to show.
But name of the creditor of the
name of the creditor also, sir. List of the creditor has to be attached.
I will send the 2-3 RPs public domain to you also, sir.
Okay. Fair enough.
Only they are classifying secured creditor, operational creditor, workman claim. They are not giving the details of the creditor.
No, sir, it is mandatory. Then, sir, it is mandatory. If anyone is not following up, then the IBBI will take suitable action.
Okay, sir.
It is mandatory to give to submit the detailed report with the IBBI.
Okay, sir.
Sir, here it is mentioned to file a certified copy of the list of creditors.
Yes.
Certified by whom, sir?
Certified by RP.
RP, okay.
Yes.
Any other suggestion on Regulation 9? Next. Move further, Suhasini.
Yes, sir. Once the list of creditors, parallelly, once the admission into personal insolvency and public notice is given, we should start communicating with the guarantor to get these details. These details are critical for the repayment plan and for the meeting of the creditors. So this is the most difficult part, and out of the 8 guarantors matters, except 3 guarantors where they were willing to give a repayment plan and close the matter, they have given these details. In the 5 guarantors details, we were unable to get all these details except a repayment plan, and in repayment plan some declaration part in the papers they provide, that is assets and liabilities of preceding 3 financial years and excluded assets if they have any, income statements of 3 financial years, income tax returns, and they have to provide us the creditor wise amount due, then details of debt owned by the guarantor to his associates for the 3 preceding years, guarantees given in relation to any debts, or and details of financial statements for the business owned by the guarantor.
Here, one of my suggestion is there is no time limit provided within how much period individual guarantor has to provide the details to the RP. So there must be a time period, and like CIRP section 19(2) is there.
That had to be submitted along with the repayment plan, sir.
Yes, sir.
So there is no separate. You have to submit the repayment plan by taking into consideration of all the facts along with the affidavit.
Exactly, and
that's why that is the last 21 days only. That is the last date. You have to submit. Otherwise, the repayment plan is not in accordance with the regulation number 17. I think that 17.
Sir. But there must be some timeline. Otherwise, our resolution plan will be in limbo.
Sir, repayment plan has to come along with all these documents. Sir.
Exactly.
We cannot accept the repayment plan.
If anyone is not providing the details, then how the repayment plan will be furnished?
That it cannot be. That is not in accordance with the regulation.
Yes, that's why I'm saying there must be some timeline, and there must be some penalty clause also.
Yes.
There must be some penalty clause.
There are so many penalty clauses are there in the IBC. That is only for applicable to resolution provisional, liquidator, and this. And how much penalty they had imposed against the corporate debtor for not submitting the details during the
19(2) is there, na?
19(2) में कितना लोग को अभी तक penalty डाल दिया सर.
Sir, if under 19.2 they are not providing, then you can invoke the section 70.
Correct. Who will invoke, sir?
I have invoked. I have invoked.
Who will impose penalty? Not by the liquidator, not by the
resolution. Not by the liquidator, but IBBI will file the case in special court. That's a criminal. That's a criminal proceeding, sir.
Taking action against the liquidator.
Yes, yes. No, sir, kindly abide with the regulations.
Okay, okay.
Yeah. So,
but he's telling that
Thank you.
So there must be some sort of alignment with CIRP, like section 19. So there must be a provision which through which we can bind the guarantor to provide the information.
Sir, I think there is a provision already similar to 19.2. If they are not cooperating, then we can move a IA in front of AA.
Okay.
So that is there already.
Which section, sir?
I couldn't readily recollect that, but there is one. Yeah,
okay.
Definitely I will get back shortly.
Fair enough. Then we will see it. Next.
Yeah, meeting of creditors. So once the list of creditors is prepared and each creditor is entitled to participate in the meeting, and the meeting will be convened by RP. Once he receives the repayment plan, he has to verify that and file an IA with the NCLT. If he feels that the offered amount in the repayment plan is not sufficient, or is if he feels that a meeting of creditors has to be called and place the repayment plan for discussion, he has to call for a meeting, and the meeting will be convened. The notice will be served to all the participants, and here the meeting notice is 14 days for the first meeting. Somewhere in the regulation it is there. Nitika, can you go a little down?
It is section 107 where 14 days has been mentioned.
Yeah, yes, sir. So, in the IA, when you file the repayment plan recommending for a creditors meeting, there you have to mention about the creditors meeting notice also.
So, any suggestion for any change? Any amendment in this regulation 11? Okay. Next, Suhasini, content of notice.
Yeah, the contents shall carry the agenda, the agenda items to be discussed, and the items which has to be voted upon, we have to provide all the relevant documents related to the voting items, like repayment plan and whatever RP has prepared, the statement of affairs given, and the supporting documents of the repayment plan. In one of our case, there were some properties given as security by the guarantors. So we have, as per the creditors request, we have done the valuation also. We have done valuation. We went for investigation of the assets also. So it took some time, and this is just an experience I'm sharing. It took some time, and we took extension also for voting on the repayment plan. Taking decision for voting on the agenda item has to be provided. It's like the same CIRP. You have to mention the date, time, venue, video conferencing, and it should be shared to the email ID which they have provided to the authorized person, details provided by the creditors. So the creditor has to provide the contact details of the person who is authorized to attend.
Any point of improvement, any suggestion? Regulation 12.
It's okay, almost okay.
Okay, next.
Suhasini ma'am?
Yes.
Ma'am, I have a doubt. Ma'am, actually
Yeah.
in regulation 11, sub-regulation 3, it is mentioned that you have to give at least 48 hours notice for the first COC meeting, for the first meeting of creditors. However, under section 107, it is mentioned that minimum 14 days notice is required. So there is some contradiction.
Yeah, there's a contradiction. So we are following the 14 days notice.
So ma'am, that needs to be changed, maybe the regulations.
In line with the section. In line with the section.
Yes.
Yes. Yeah, the like CIRP, RP will preside over the meeting as a chairman, and as usual, he'll take the roll call of the participants and record the name, capacity. Then he'll inform the participants the quorum. The quorum is 33%. It's almost like CIRP, the conduct of the meeting.
Nitika, just sorry to disturb. Regulation 11.3 talks about the first meeting, and section 107 is the common procedure of the calling of the meeting of the creditor. So for the first meeting, at least 40 hours before notice has to be issued. Minimum 48 hours notice shall be there. And for further meeting, section 107 will be applicable.
But sir, anyway, section 107 is blanket. For every meeting they are saying. So we cannot
Actually, I'm sorry. Actually, if you look into section 106, subsection 4, okay, which says that the date on which the meeting is to be held shall be not less than 14 days and not more than 28 days from the date of submission of report. Meaning, the moment you are going to submit the report, okay, from the date of report, that 14 days. So what Nikita said is perfectly right, and I completely concur with her. But this 48 hours notice is like 14 days. At the time of 14 days, no? Okay, after, like you can do it on 12th day and calling for the meeting from 14th to 28 days. That is the meaning of that particular sentence. This is what is my interpretation. See, if you look into it, they say that 48 hours. So the notice should reach the creditors 48 hours before the meeting. Meaning, you can conduct the meeting within 14 to 28 days by sending a notice for them at least 2 days before the meeting. Say, for example, you want to hold it on 16th. You are supposed to send it on after 14. That is what is the meaning. But either way, as you have rightly said, we can ask for a clarification regarding this.
No, there clarification is required.
But as a caution, we are giving 14 days, just a notice we are sending on the day of filing the report. And we are giving
and ma'am, one more point, sorry to interject. So in the report as well, I think we need to mention the date of the meeting of creditors, the first meeting of creditors, if we are calling for.
Yes.
Then that has to be mentioned in the report as well, right?
Yes, we are mentioning, yes.
Okay.
Actually, Pankaj and ma'am, this period of 14 days is too much. I think it should be reduced to 7 days.
Sir, that is in the code.
Sorry?
Code, yes.
Sir,
it is in
that
the code.
14 days is in the code.
Okay, no, but I'm telling you 7 days you can recommend because sometimes, there are emergent matters or there are urgent matters. So they can be taken up, at a short notice also. Are you with me, Pankaj?
Yeah. But see, IBBI cannot change the code now. It will be amended through Parliament only. And regulations are in the hand of the IBBI.
Yeah, but some way out should be there actually.
That we can recommend it can be clarified under regulations.
Correct.
Fair enough. Next, quorum.
Yeah. Contents is completed.
Contents, quorum is okay.
Yeah, quorum is same. Conduct also we completed.
Any suggestion on conduct of meeting? Okay, then voting by creditors, any suggestion? Voting by creditor and voting by proxy. Yeah. Voting by proxy, regulation 16, any suggestion? No? Next, Suhasini, please, repayment plan.
Yeah, contents of the repayment plan.
Yeah, it is very important.
Basically, yes. The repayment plan will provide the plan which he is proposing to pay to the creditors and the source of funds which are available with him and the duration of the repayment plan, wherein he has to take care of the personal insolvency process expenses also. And in case any funding requirement, the source of funds, the details on the implementation of the plan, during implementation plan, how he is going to fund, and if guarantor has any business, the manner in which it will be managed, and how the repayment plan will be implemented, how it is supervised, and in case is there any onerous terms of a contract or transaction involving the guarantor, and details of excluded assets, and basically the terms of discharge of the guarantor and what are the terms he is proposing to the creditor, also the guarantors are proposing. So Nitika, can you take it a little down?
What is the maximum period of repayment plan or anything? Should we not prescribe something like that?
No, sir. No, sir.
So it will be depend upon the COC sort of thing. Like under resolution plan, COC has the power to vote and confirm the resolution plan. In the same way is the repayment plan. Am I right, Suhasini?
Yes, sir. Repayment plan usually, like practically, the guarantors are offering 6 months to 1 year. Mostly the creditors are negotiating for 6 to 9 months. In one of our case only, we got a repayment plan. 6 months to 9 months they are offering. 6 months to 1 year.
When the amounts are high, it may take higher period, no?
Sir, this is similar to CARP, where the resolution plan period is not mentioned.
Okay,
yes,
okay,
yes,
got
yes.
it. Okay, right.
Built our head here.
Okay, okay, got it.
Not mentioned. No mention.
Yes, yes.
Any suggestion for improvement? Regulation 17. Then regulation 18, purchase of assets by certain person.
So when any guarantors assets are purchased or acquired directly, this has to be done only with permission of the AA. Directly, the following person shall not purchase or acquire without permission of AA. So the below persons cannot buy the
yes, yes.
assets. Yeah, these are general. Yeah, yes, sir.
Next.
So the resolution professional has to prepare a report along with the minutes of the list of creditors and voting on the repayment plan. As per section 106 and 112, that is, maybe the repayment plan is approved or repayment plan is voted against. Then the RP, based on the decision of the creditors, he has to file a recommendation to NCLT recommending for the order under 106 and 112.
Here one small
So
issue.
either the
One small issue, Madam Haru. Yeah. Regarding that 40 days notice issue for the meeting, is it necessary to take a approval from the adjudicating authority?
No, sir, it's an intimation, sir.
To whom intimation?
See, when we are filing a report with the NCLT about the repayment plan, it's only for taking note. It's not for any order.
No, here some misconception is there. In Hyderabad, some of the resolution professionals, for that also they are filing an IA for taking a approval, conducting a meeting. But as per the section, I think that is silent.
There is no need, sir. There is no need.
That's right. No need. It's silent.
Yeah, no need.
Sir, we are also from Hyderabad. Sorry.
Your good name,
we are also from. Sorry, I am Suhasini, sir. We are also not taking any approval, sir. We filed with NCLT Hyderabad only. Concluded.
Very good. Process. Some of the people are telling seniors, no. You have to take
unnecessary burdening the adjudicating authority.
Yeah, not only burden, sir. Yes. Again, you have to file a IA.
Yes.
Not required, sir.
Any suggestion for this regulation 1920? I think it's general as per CIRP.
Yes. Yeah, non-cooperation regulation is there, sir. Here in the event non-cooperation during process, we can seek an appropriate directions.
Yes, correct.
Yeah, it's there. Then if the repayment plan gets approved,
regulation 22 is something different from 19.2 as CIRP. Here we have to just submit the statement. We cannot seek the directions for cooperation.
Okay, statement to the effect and file the same with the AA for appropriate directions. It is.
No, it is the AA has to give directions. That is
AA has to give the directions.
Direction also, sir. Direction also.
Yes.
Yeah, to that extent, it is almost similar to 19.2. Only thing is that we are seeking directions from the AA.
Yes.
Right. Now, any suggestions in this personal guarantor regulations?
Sir, the first and key suggestion would be regarding the fee similar to whatever we have in CIRP.
Exactly.
There should be something as a minimum benchmark.
Minimum benchmark should be there.
Yeah, and the second thing is, sir, as far as reporting on IBBI website is concerned, currently we do not have the scope to add this as an assignment, though we have option to submit IP1 form for PG to CD assignment, but we can't add this as an assignment. So even that has to be looked at.
Right. Nitika?
Yeah.
Sir, again, it becomes burden, sir. If you add as an assignment, all the compliances keep coming.
Recently,
that is correct. Actually, Suhasini, I am with you. Actually, too many CIRP forms, too many IP forms.
Yes, sir. Yes, sir.
Very big burden. At least let them leave off in this portion.
Yes. As of now, we are doing section 208 reporting in personal guarantors matter, sir. We are only reporting whatever we are filing with the NCLT. We are reporting to IBBI and IPA. We are sharing emails.
Yeah, that's mandatory under section 208.
Yes.
And, sir,
Nitika, we can recommend that there must be some benchmark of the fees, minimum fees. Like under CIRP, IBB has provided. In the same way, under PG, there must be some prescribed fees.
And sir, one more suggestion, or I would say, like practically speaking, what has happened is in one of the case which I am handling. So there are 4 personal guarantors to the CD, and NCLT Hyderabad bench has given 4. I mean, they have split these petitions into 4, and they have given these assignments to 4 different resolution professionals. So this becomes, as we can understand, becomes difficult to coordinate as to what's happening. So they are a different wavelength in each of the cases. So somehow, I mean, from a petition section 95 point of view, I think it is not compulsory for the financial creditor to name the resolution professional in their petition itself. If that had been there, then this could have been circumvented. So what I'm trying to say is, so I got this case from NCLT panel route. So the instant case, they have split into four different RPs have been assigned by NCLT Hyderabad while giving these assignments. So yeah, hope I'm clear in.
Yeah, it should be the decision of the. It means NCLT has to make the decision wisely.
Yeah, and there is also need to check section 95. So if we compare this, I mean, whether they have to, I think it is open whether they can mention the RP or may not.
We can do one thing, in my view, under regulations, we can suggest to IBBI that for one corporate CD, all the guarantor shall be under one roof. Means one RP will deal with all the guarantors.
Correct.
One more thing, whether the liquidator can accept the personal guarantor cases?
No, sir. No, sir. It is there in the regulation. Eligibility is not there. If you are an RP or liquidator.
Instead of giving to others, you know the entire data of the thing, company, CRP and all the things.
Yes, that we have earlier discussed now. We have we are giving the suggestion to the board.
Okay.
Yes.
Sir, I am Sudhakar from Hyderabad, sir.
Yes, sir.
Just I want to suggest, sir, after getting repayment plan, and the corporate debtors and guarantors are not cooperating fully, sir. They are not submitting the information as per section 17(1) and 2. And the statement of preparation of statement of affairs is very difficult. I am facing a lot of problem in this also. I faced. That is why I am suggesting RPs first see the repayment plan and get the information, the statement of affairs, compliance certificate. Then only it is better to proceed, sir. That is my suggestion, sir.
Okay.
And hurriedly they are after getting repayment plan, they are conducting meeting and plan has come and I accept like that. The financial creditors also objecting without statement of affairs. In my case, SBI financial creditor, they are fully objecting without getting full information how you have prepared your statement of affairs and other information also required by the financial creditors is not given. They are not cooperating. Compliance certificate must be certified by the RP. All the as per IBC guidelines, he gives your certificate. They are insisting the RP for giving the certificates and all. And it is better to see all these aspects. I am suggesting.
Have you filed any application with AA?
Yes, sir. I filed with AA also, sir. NCLT Hyderabad.
Okay. Then
I filed. I asked information on cooperation also. I filed. Everything was over, sir. Afterwards, finally has given, but financial creditors is saying it is not as per IBC. We want to reject. They are saying like that it is not moving. 1 year, 3 months is over, sir. That PG case, it's going on. These are the problems in PG case. So just I am suggesting to the RPs to go very carefully at the time of repayment plan, taking statement of affairs and the compliance certificates. Everything should be satisfied, sir. Then only let them proceed. This is the suggestion, sir. Experience.
Thank you, Sudha. Thank you, Sudhakar. Good suggestion. Good suggestion.
Yes, sir. Fair enough, sir. Thank you.
Yeah. Any suggestions and any experience sharing by other IPs?
Sir, in some of the guarantors, they are staying in USCA and other places. And sending the notice itself by postal, they are not sharing the email addresses. 10 to 15 days time itself it is taking. Giving the report within 21 days from the date of receipt of claims, I think it is better to increase by at least 7 days. 30 days देना अच्छा है. Now 21 days में from the date of last date of 7 days, we are getting only 21 days from the date of verification of claims within 21 days. So that is not enough. I think better to increase either at least another 10 days, 7 to 10 days. Then the resolution professional is having some breathing time. Otherwise, neck to neck ho jayega.
Okay. Any suggestions on this timeline?
Yes, sir. Even we are facing the same difficulty, like sir.
Okay.
Sir, Pankaj, one typical situation is there that there are two guarantors. They are residing out of India.
Okay.
How it is to be resolved, and they are not responding to the email and communications. So how we can take the legal action under section 19(2)?
Sir, and section 19.2 will not be applicable in the PG.
22. Regulation 22.
Regulation 20.
नहीं,
Mr. Amarnath, kindly mute yourself.
उस पे अपन कैसे करें सर पंकज जी, जो ओवरसीज में हैं और they are not responding.
We have to file application with nothing in our hand, sir.
Okay.
Oh, can't we not expect some regulation to come inside so that the RP
Sir,
are
already non-cooperation regulations are there.
Regarding the non-cooperation, I'm talking about the people traveling abroad without informing the RP or IRP or whatsoever the nomenclature according to the regulation.
Sir, if the guarantor are already settled in abroad, then how the RP or IRP?
No, if it is already settled, it is okay. You have no options. But after commencement of the proceedings, either it is CARP or IEP or whatever it is, when they leave, without it goes without the notice. Actually, you have nothing to do with that, and later on you land in trouble on this.
Definitely, sir.
Because why not give RP some powers where everybody, whosoever is under CIRP or anything, he should inform the RP before leaving the city.
Rather inform, not only inform, take his concurrence.
Take his consent. Yes.
Sir, it's better to file the IA before the NCLT.
And
sir, we can.
But for everything, we cannot keep on filing IAs only.
Sir, no.
Because in my case, I filed one application without moving outside country by the suspended director, sir. And we are able to discuss the same thing in COC before filing application before the NCLT. My COC members, they suggested better to inform and stop any movement from India to outside country without informing to the COC members.
Sir, that is CARP okay, sir. Personal guarantor issue may.
No, we are
that
not
only, sir. In the personal guarantee also, if you are filing an application before the NCLT, at least they will say something. That I am trying to say.
Yes, because IBC, it is not a criminal suit. No, you cannot proceed like that.
We cannot restrict.
And it's very difficult to get a favorable order also.
Yeah, because it enters the fundamental rights. No, that there is a conflict.
Yes. We cannot restrict the liberty of any person.
So, Pankaj ji, it is very difficult to go against the foreign overseas promoter guarantor. This is the nutshell conclusion. Is there?
Yes.
Correct.
And sir, even whosoever has run away from our country, even our enforcement agencies are not able to come them back.
No, otherwise there should be a general consensus of amending law that whoever is taken loan from the bank. Okay, if there is a default, there is a mechanism by which we can file a petition with the passport authorities to import the passport. Only then such things are there. Otherwise, no. If from IP level or IPC level.
If RP feels that any personal guarantor or suspended directors will run away, then he can file the application with the NCLT for seizing the passport.
Pankaj ji, there are so many. Pankaj ji, there are so many litigation is pending with the A, and we are all aware of that. Yeah, how much time they are taking.
Sir, we cannot take it on personal level. Nothing is in our hand. We are just.
But sir, can NCLT seize has the power to seize?
Yes, NCLT has power. NCLT has power to seize the passport.
Okay.
We had done it.
Okay. Good. Glad to hear that. Okay. Then pursue that way. Those are all the available means.
Second thing, before filing regarding this exclusively, this one, promoters are very, very serious after seeing your application. So better to discuss with the COC. So tomorrow COC will say the RP has not discussed anything with me. They filed. Okay, they will tell orally. Better to mintage.
Exactly.
Before filing this.
Sir, we are just the process advisor. Nothing more, nothing less.
Yes, and the second thing, once you go in that application, they will very, very serious by the suspended directors. I have practically seen in one company.
We are just the process advisor for the COC.
And even you are filing contempt application, whenever they are not cooperating, we will get the non-cooperation direction also. Before you are filing contempt application, better to take approval from the COC member. Nowadays, judges are asking, once we given a direction in the 19.1 non-cooperation,
and again you are filing contempt application, whether aware of COC or not. Previously, they are not asking, but nowadays they started that one also.
Okay. So any other suggestions in this PG regulations?
Sir, one more point, sir. Is it the duty of the RP in personal guarantee to go for investigations or any civil reports to verification, or in going to sub-registrar's office, or any ECS houses are there? Any duty is there, sir?
Sir, it is the duty of
financial creditors are insisting, sir. You have to acquire. You see, sir, the civil.
Yes, it is the duty of the RP.
No, sir.
Investigations and all.
Not investigation, sir. Available information, to collect the available information.
Information I have given, sir. We have given available information. We prepare statement of affairs also, but they are not satisfying. If you get one information, they are asking another, and they are asking like CRP process. They are asking like that. One more point. In the meantime, one arbitration case has come, sir. What happened in that case? That the guarantor is a partner in one firm, sir. He resigned from the partnership in the year 2021, but our PG case started on 11/4/2022. Arbitrator is asking RP to be implemented, and I have to attend the arbitration case. We do not know, we don't have any records or any information with the RP. Is it necessary to attend before the arbitration, sir?
Sir, you can take the shelter of moratorium.
Moratorium already lapsed, sir. It is 180 days only, sir.
Okay.
Already 180 days only in PG cases, moratorium. After 180 days, what to do?
Discharge order has come or not?
No, sir.
Repayment plan has to be approved. Then only it will come. No, sir.
If it is approved, without approval of the plan or anything, how can we do all these things, sir?
No, so then you sought for the extension.
Extension, sir. Already taken extension, sir. Okay. Now it is going on 1 year, 3 months, sir. It is not finalized. The financial creditors are not approving or rejecting anything. They are not saying yes or no. It is going on like that, sir. And
then you should file application against the financial creditor that they are not taking any decision.
Yes, I have already filed, sir, and they called also. NCLT called COC members also to attend the attend the NCLT. They also attended the meeting, sir.
This is the only way, sir. This is the only way.
It is going on like that, sir.
Yes, this is the only way.
Is it that all these things? If a plan is approved, we can do something, sir. And what they are asking. Other guarantees given, they are asking, sir, information on the bank account copies also I have to obtain from foreign also. Foreign branches, they have availed loan guarantor. Here they are asking all those account copies you obtain. They are
financial creditor has put all burden on you.
All burden on the RP only, sir.
now
they are saying everything should be done by the RP only. They are telling like that, sir.
Now you have to run from pillar to pillar and to gather the information for them.
I gathered, sir. Step by step I have gone and I have done all the things, sir. I have given information also. Now
I think, Suhasini, we have completed this PG regulations. So,
yes, sir.
There is nothing much more for the suggestion by the fellow IPs. Nitika, can we move further?
Yes, sir. Just give me 1 minute.
Sure. In the meantime, Suhasini, you share your experience.
Sir, even we have one of the case where the NRI settled PG is there, and on his behalf other guarantor is coordinating with us. So it would be a good suggestion, as others have given. We should have a regulation on the foreign the guarantors residing in foreign, sir, for getting the information.
Okay.
That is one point. And for this repayment plan and going back to the creditors, again it's a Hercules task, as sir sharing his experience. The creditors, although they have all the information.
So what is your suggestion so that we can suggest the IBBI for amending the regulations?
Regarding the regulation on the personal guarantor to the CD residing abroad, sir.
Yeah.
Oh, so for getting the information to the RP, there should be a regulation which should help RP to get the data.
Other suggestion?
Facilitating.
Other suggestion?
Other suggestion, can I say something?
Please, Ranjan.
Other suggestion can be that if like this for last 2 years, they PG, if he is residing abroad or residing in India also, if he has disassociated himself with some assets, that can of Indian assets firstly, that can be repatriated.
Okay.
So that something can be recovered from that. For 2 years or for 3 years, like in case of CRP, there is one procedure of 2 years before IBC. So before IBC, that should be there. Before IBC, if there would be any asset that had been sold by this guarantor, then that can be repatriated. That may be a yes. Only then they will be interested in the.
Okay, fair enough. It means there is no provision against the PG who has sold their asset 2-3 years before the IBC. Then there is no provision to recover that asset, like under CIRP.
It is not there in PIRP, but in bankruptcy it is there, sir.
Yes,
yes. Yeah.
Pankaj, just a query here.
Yeah.
Whether NCLT has the power to execute under section 68, 69, 70?
No, sir. IBBI has, NCLT has no power. There are special code designated under the Companies Act. So RP has to file application to IBBI, and IBBI will file application in concerned special court.
Okay.
Yeah.
Thank you.
Now this bankruptcy process for personal guarantor, it is just like the liquidation. Yes. If the repayment plan is not approved or declined by the financial creditor, in the same way, the individual will go under the bankruptcy. So we should move from regulation wise. Yeah, carry on, Suhasini, please. Any suggestion for improvement on regulation 1 and 2 definitions? Any suggestion? No? Then regulation 3, the eligibility criteria. Same as the RP or
जैसे 6 resolution है ना सर, तो वो individual.
Sorry. Kindly unmute yourself. Okay. Carry on, Suhasini, please.
Yes, sir. The eligibility conditions where bankruptcy trustee cannot take up the process. It is more or less like other eligibility criteria, that who has been an auditor at any time preceding 3 years or acted as IRP or liquidator in respect of CD. There is no bar if you are a PIRP, you are an RP during PIRP, there is no bar to continue as a bankruptcy trustee.
Here under regulation 4, I think there must be some minimum fees shall be fixed by the board.
There's a prescription.
Otherwise, committee will negotiate the fees with the IPs, and then IP will start to quote 1 rupee, 10 rupee, 1,000 rupee, 5,000 rupee like this. So it will be better in interest of all the stakeholders that there must be some minimum benchmark of the fees.
Sir, like liquidation, here there's a percentage on the amount realized and distributed.
Okay. But
Schedule 1.
like liquidation, nowadays bank has started to negotiate with the IPs.
Yeah.
Whatever fees it has been mentioned under Regulation 4 of the liquidation regulation, they start to negotiate 10%, 5%, 25%, 50%, like this.
That is the reason.
Actually, if it's the quality of the RPs,
So even that
I think what we should do is we should get the minimum fees listed.
Yes, that there must be some minimum benchmark. Below that,
there should be some minimum fee slab.
Yes. That's why I'm saying there must be some minimum benchmark.
Sometimes the personal guarantor, they don't have too many assets, then it's a problem.
Exactly.
Yes.
So there must be some minimum benchmark. Okay.
Yes.
Next.
Then the appointment of professionals. During the process, the bankruptcy trustee may appoint any professionals, but there is again the below persons cannot be appointed. That is like other processes relative of bankruptcy trustee, a partner, director, or who has, you cannot appoint an IP who has acted as an IRP or RP during the liquidation or CRP process, and related party.
Suhasini, sorry to disturb you. Is there any example where the bankruptcy trustee has been appointed by any NCLT till date?
Yes, sir.
Yes, sir.
Okay.
In NCLT Hyderabad, there are a few
Multiple
cases
are there.
Okay. Fair enough.
Yes. We were there as a RP in one of the matters where repayment plan was a good repayment plan was offered. Then the creditors have rejected because they had some security assets which were valued more than what repayment plan they have offered. So they asked us consent for bankruptcy trustee, but as you said, the fees quote by the IPs was very low, sir. Our IP fraternity quoting.
I think we should not discuss it at this forum. That's why we suggest there must be some minimum benchmark.
I'm sorry.
we can discuss, but we should not disclose.
Yes.
So we have not taken the process and it has started the case.
Okay.
And register of this is regulation 5(6).
Any suggestion under regulation 5(6)?
Again, the preservation period should be mentioned.
Right.
And one more here is, sir, the first regulation 6(1), where the books of accounts of bankrupt are incomplete on bankruptcy commencement date, the bankruptcy trustee shall get them completed. It is shall get them completed within 60 days.
I could not understand. Any individual are maintaining books of account if his or her income is below the prescribed limit. Then why this wording is mentioned here?
Yes,
and
sir.
Under the CIRP, under the companies, we can fetch the record from the MCA, previous record. But
yes,
how the bankruptcy trustee will fetch the records for completion of books of account? That's the main question, na? So I think the duty should not be cast. Duty should not be cast on the trustee. What's other views?
There may be one suggestion. There may be one memorandum of assets and liabilities of the bankruptcy of the bankrupt of the PG in that case only, so that he would share.
Exactly. Only the memorandum of assets shall be there.
Yes.
Good suggestion. Any other suggestion? Next, Suhasini.
Yes, sir. Here, like liquidation process, there's a preliminary report and progress reports we have to file. And on conclusion on payments, a final report has to be prepared after getting the audit. So the bankruptcy will prepare a preliminary report within 90 days and then he will send this to the AA. And the preliminary report will include the assets, liabilities as on commencement based on the books of bankrupt. Again here it's based on the books of bankrupt, sir. And again there is a condition in case books of bankrupt are not reliable, then bankruptcy trustee can provide such estimates based on the reliable records.
Okay, next.
It's a format kind of thing, contents of the preliminary report. So wherever available information we can fill, wherever not available we can write our comment against that.
Next.
And the preliminary report is confidential.
Here also, ma'am, here also the format should also be given in these regulations.
Content of the preliminary report is given.
Formats of these, you know.
Anyhow,
that is same as the liquidation preliminary report.
Yes, the contents are given. Yes, based on this we can prepare a report.
Contents are given in the same way. Okay, next.
And the preliminary report is confidential during the bankruptcy process. AA permits only, it can be shared, accessed.
That should not be shared with that should not be shared with financial creditor even. If financial creditor asks for the preliminary report.
But as per the law, that is not allowed, sir.
Yes, that is not allowed.
As per the CARP regulations, you may tell the outer values we can tell without disclosing.
To access any
outer
value we can, as per the CARP guidelines.
I put this question willingly because it is the main hurdle for the IPs. If financial creditor asks for each and every information, whether they are eligible or not.
Sorry.
Yes.
They made the pressure on IPs and seek the informations.
So financial creditors ask, they are having their own limitations. RP is having own limitations.
Yes. That's why I willingly put this question.
There is one controversy.
Where RP had to take his own stand. This is the rule. This is the section. This is the regulation. As per the regulation, the regulation says only outer value this much, 10 rupees, 20 rupees. We need not discuss piecemeal valuation or discussions with the COC or financial creditors.
Right.
That is the law says.
Next.
Then early completion of administration after filing preliminary report. At the time of preparation of preliminary report, or after filing, if realizable assets are insufficient to cover the bankruptcy process cost, or the bankrupt affairs does not require any further investigation, he can always file.
Any suggestion on this point? Then progress report, it's the procedural aspects.
Yes, sir.
Any point of improvement under regulation 10 for progress report? I think it's the same way as the liquidation and it's the procedural thing. Yes. Then final report in the same way as the liquidation. Yeah. Any suggestion on regulation 10-11? Then regulation 12, same. Who can extend the cooperation?
So we can seek cooperation from all these persons.
Same way, sub-regulation.
Consultation. Yeah. In the consultation with the creditors, the records have to be maintained by the bankruptcy trustee. Then again here we have a regulation. Whenever after making reasonable efforts, bankruptcy trustees fail to obtain any information or cooperation, he can make an application to AA for appropriate directions.
Regulation 13, preservation of the record. Here also no timeline has been prescribed.
Yes.
Nitika, is there any thing come out after the consultation by the board with IPA?
Sir, which discussion paper?
Regulation 13.
So right now we haven't.
There is no such communication. Na? Yes. So I think there you should note it down. There must be some time period or some clarification from the board should become. Then claims. Carry on, Suhasini.
Here, the person who is entitled for distribution, he has to submit the claim. The claim amount should be the claim as on dues as on bankruptcy commencement date. It includes principal and interest.
Any suggestion on Regulation 14-15?
One thing, sir.
Yeah.
It's better to conduct some sessions on this personal bankruptcy, sir, because particularly in some Hyderabad, more and more cases are coming up, and we are not that much acquaintance with this.
So we can do 1 day, full day seminar on this.
Half day full day also welcome, half day also welcome, because at that time you know something about the. Otherwise, it is very difficult to face this situation, because reading book is okay, but some practical issues and all the things is better to conduct half-day seminar.
Nitika, can we keep this by seeing your diary?
Yes, sir. I'll discuss and then we'll share.
Yes. For personal guarantors and bankruptcy trustee, 1 day seminar.
Sure, sir, we'll do. On Saturday, most probably we'll do the full day workshop.
Yes. Okay. Then any suggestion on 15, 16? I think it's the practical thing. 17, determination of quantum of claims. Debt in foreign currency.
Yes.
Same thing.
It's same like
thing, same thing.
Same 19, 20.
Yes.
Yes, same. These are all the practical things.
20, the bankruptcy trustee will have to prepare a report. Yes. Shall report the establishment of committee within 3 days from the meeting of creditors.
Same way. Then 21, notice of meeting, quorum. It's all the practical things which we have discussed in CIRP liquidation.
Yeah.
Sir, one more thing, sir.
Yeah.
14 days notice is required in personal guarantor cases.
Sorry.
When personal guarantor cases, 14 days notice is the.
Yes.
It is required for 14 days. When CIRP are conducting 5 days to 2 days, reducing to 2. Why you are thinking in that direction?
Sir, it is under section 107.
Whatever it may be, sir. In the CIRP main cases, we are going to 5 days or 2 days.
Right.
What is the need of 14 days? Any logic is there?
Yes, Suhasini, kindly explain.
No, in bigger cases, we are conducting within 5 or 2. The personal guarantor cases are, when compared to CIRP liquidation, very small. Very small cases.
I am 100% agree with you.
It is better to take reduce to 5 days, sir.
But that is mentioned under the code.
These are all unorganized sectors,
No.
so you have to
Yes.
give little bit of leeway.
Yes,
That
yes,
is only
yes.
the
That
thing.
is the reason, because you will fetch the information from the individuals, not any corporate person.
No. Whatever it may be, sir. Here, notice may, I am not going to get any information in the note. 14 days may I am going to get to 5 days may I am not going to get. That is not there. Here I am talking notice period 14 days. What is the logic that I am? So I think it is better to change 5 days.
Okay.
Sir, that is in section, so which cannot be changed. And sir, this is applicable only for one meeting, sir, first meeting.
नहीं, second meeting में भी कम करने का कहाँ है मैडम? नहीं, what I am telling is,
no, for regulation it is mentioned for the first meeting, but under section 107 it is blanket for 14 days.
That's why I am telling. Even section also, whenever it will go to amendment to the, it will go. But first you have to start the.
We can suggest, Mr. Goda, we can suggest to IBBIA for amending the code also.
Yes, correct.
In parallel with the regulation.
First meeting we are taking 14 days time, sir. Second meeting with by giving 1 week notice we are conducting, sir.
Okay, but it is nowhere mentioned, Mr. Venkat.
Conducting
not mentioned. That's why we are taking 1 week gap.
Conducting
107 under section 107 it is mentioned 14 days only.
Yes, for every meeting.
Anyway, so we have to seek this clarification from the board in this regard.
Yes,
definitely.
Yes. Then regulation 22-23, it's the practical procedural matter. 24 voting share.
Yes.
25 voting by committee, same way. 26 voting by proxy. Any suggestion on these regulations? Then 27 mode of sales. Same way during liquidation. It's I think it's crystal clear. Any point of discussion?
No, sir. Nobody knows, sir, that most of the people who are not aware of that bankruptcy individuals. Mostly, that's why requesting half day, 1 day seminar is best.
So we can do one thing.
Practical experience is not there, sir.
Yes. So
that is why we can't give suggestion.
No, sir, suggestion. See, practically reading and practically doing is something different. So after reading, if we analyze that there must be some improvement, that we can suggest as on date. No issue. We can do one thing. Each of us should go through the regulations in day or two, and then we can write to IPA for giving our suggestion.
Yes.
I think that will be a better option.
Yeah, for bankruptcy regulations, yes, sir.
Yes, that will be a better option.
But whatever the case is pending with the Supreme Court, we have to expedite one way or other way with the help of the IBB, IPA or Union of India, whatever it may be there. Then it will be effective, sir.
Sir, that is there. Even Supreme Court has issued notice to IBBI also. And IBBI is giving reply in that matter. Lot of matters are pending there. All are clubbed with the Bhushan Steel. Similar case.
And one more thing, sir. So many cases are there pending with the NCLAT, 2 to 3 years, CRP liquidation pending. 1 year, 2 years, 3 years.
But that is not in our hands.
But
that is not in the hand of IBBI also.
Sir, RP is accountable for everything. IBBI, IPA, Supreme Court, High Court, NCLT. But the judiciary authority is nowhere accountable for any authority.
It is everywhere in every law.
That is the reality. You accept it.
And we have to accept it and we have to do work under these circumstances only.
Yes, yes.
So, Suhasini, anything
Yes.
else?
Sir, I think it is a good suggestion regarding the patients. We can give a suggestion, sir.
Right. So, Nitika, you can share your email ID with all so that anyone can give their valuable suggestions.
Yes.
So now,
I
I think, Suhasini, we have done with our job. Anything you want to say?
Personal insolvency problems, IPs. Bankruptcy, we have to go through in detail and.
Okay. So, Nitika, we can keep one session.
Sure, sir. Maybe most probably next Saturday we'll do. This Saturday we have a scheduled workshop.
And in the same session, we can ask for the suggestions.
Okay, sir. We'll do that.
Fair enough.
Sir, I want to suggest one point, sir. In personal guarantee cases, the
Yeah.
moratorium is only 180 days. It is given in the Act, sir. Regulation.
120 days.
120 days only. It
Yeah.
should be extended, sir, because the PG cases are not completed within 6 months or 180 days.
Obviously, it extend.
It should be extended. It is not clear.
Yes,
Sir.
yes.
It is silent in
Once,
the.
no, sir. Once the extension has been granted by a moratorium, will automatically be
Automatically, it will extend.
Yes,
yes.
I see. Under moratorium, it is.
Yes.
Exactly. So
That is
there is one suggestion from me.
Yeah, please.
Regarding CRP, with effect from October 1st, 2022, IBB has permitted minimum fee for IPs in case of CRP. But even then, many banks are asking for quotes from empaneled IPs regarding the fee. So when there is a clear-cut guidelines from IBB regarding CRP fee.
Sir, banks are asking for the quote, then IP should not give below the minimum prescribed limit, and above that they can give, they can quote.
Okay, that some people are giving some. I don't know. I have any proof, but I hear that they are giving, but I don't comment on that. But why banks are asking? When IBB has prescribed the fee,
if you want
there
to
is
quote
no
more
point in
than
the bank.
Sir, board has provided minimum fees. Board has provided minimum fees. If I want to quote 10 lakh rupee, who bar me?
That is not
okay. That is there, but that has to be the decision has to be taken, taking the marketing conditions on the others based only by two people, applicant or COC. It is up to COC, not by the bank.
Depending on the size of the company.
I have read the guidelines, sir, regarding the over and above the minimum fee prescribed by IBBI. The concerned authority is applicant, either FC or OC or COC.
I'm sorry, it's not the point of discussion. That's the individual capacity. We have to abide by the ethics and abide by the regulation.
My request is you from IBBI, maybe they can advise.
No, I am not from IBBI, sir. I am not from IBBI. I am just like
we can suggest now. We can suggest. Banks are, of course, they are published undertakings. They are asking again, once again.
Why do you want them to keep quiet? See, you can put higher amount. If the case deserves higher amount.
That's why I'm saying, sir, it's not have any point of discussion.
Yes, there is no point of discussion because the IBB has prescribed minimum fees. You can charge maximum also. There is no.
But all a person goes under the minimum, then it is a fault.
Under the
otherwise,
minimum,
there is nothing wrong in it asking. No.
Exactly. Over to Nitika now. You can.
Sir, so far, how many repayment plans are approved, sir, in India?
We don't have any idea.
But in personal guarantee cases, what is happening, sir? Personal financial creditors are expecting recovery, sir. The claims are in thousands, crores, 1,400 crores, 600. My case is 700 crores, like that. And the guarantors are offering 1 crore, 2 crores, 2.5 crores, like that only. That is why plans are not approving by the financial creditors, sir. It is not going successfully.
Let them.
All the cases are recommending for a bankruptcy trust.
Let them be the bankrupt then.
Yes, sir. It is going on like that in personal guarantee cases.
Personal guarantor cases, 2,000 crores, 500 crores. How a personal guarantor will pay 500 crores, sir? When CARP paid, CARP not received, how a personal guarantor will pay? Whether the net worth is there, personal guarantor net worth they are taken, they cannot give any net worth statement. They cannot give any back assets.
Sir, I am sorry to say, it is the fault in our financing system.
Yes.
Yes, sir.
Okay.
And
so firstly we had to correct the root cause of this insolvency and all that thing.
And the guarantor is signing on behalf of the company, sir. When he was a
and root cause is the faulty financing system.
For thousands of crores, they are signing guarantors to the company. But personally, if you see, they don't have any properties. They are saying we are having 1 crore property, 2 crore property. That's all. Nothing we can give. They are saying bankers are not accepting it all.
I simply ask from the bankers, as per the loan agreement, bank mentioned that bank can take over the management of the company. I ask every time from the bankers, how many corporate debtor you have acquired, when the debtors has been wiped off, when the stock has been wiped out.
What action they have taken?
As per guarantee policy of each bank, whenever they are accepting a guarantor, equivalent net worth, equivalent amount of loan amount to persons only they have to accept. But whether they are doing that,
if that is there,
then you see any bank loan policy,
there cannot be any financing in India.
My friend, then the finance, the so-called loan system will not work, my dear.
Yes, that's why I'm saying that.
But why IRP, RP or bankruptcy is liable for that? You please tell me.
No, it is not liable. See, these are all systems to mitigate the risk and also find a resolution for when something is stuck. That's what we call stress test. Okay.
Sir, if the bank are taking guarantee as per the net worth of the individual, then
Mr. Koda, it's my humble request, don't stick to the assignment. Don't get emotionally involved in the assignment.
Sudhakar Rao is telling that is 100% prevailing in the market when there are no assets with the guarantee.
And even if you have assets also, actually 1 crore rupees value of asset, they are going for loan. That time they will show as a 10 crores valuations. And if it will come for CARP, not even 10 lakhs, they are not showing as a property.
That's why I said the root cause is the defaulted financing system.
Correct, sir.
In the meantime, they are transferring their assets also to in the name of our father, mother, and other people.
Anyway,
nothing will be there.
I think we should call off the session.
Sir, yes, we are diverting from this. Yes.
Nitika, are you there?
Valuable discussion, sir. Thank you, sir.
Thank you, sir. Are you there?
Thank you, everyone.
Thank you, sir. Thank you very much.
Thank you so
much. Thank you, sir. Thank you, everyone. Thank you, sir.
Thank you. Wonderful session, sir.
For allowing discussion, thank you very much, sir.
Thank you, sir.
Thank you.